The In Duplum Rule has been part of South African law for more than 100 years. Translated, In Duplum means double the amount. The common law In Duplum Rule provides that interest on a debt will cease to run where the total amount of arrear interest has accrued to an amount equal to the outstanding principal debt at the time of default. I am Michael Lilly, and I will try and simplify this concept. I say try because it can be confusing, and even our courts have seemingly in the past differed in their opinions of this rule. Just to repeat what I said just now, In Duplum means double the amount. First, a bit of background. There are mainly two types of law that we are concerned with when we discuss the In Duplum Rule. The first one is common law. Common law is that body of legal rules that have been made by judges as they issue rulings on their cases in the past. Future similar cases thereafter, the decisions are then based on the previous ones. Common law is mainly unwritten law and is developed over a lengthy period of time. The first type of law that we are concerned about is common law, and the second one is statutory law. These are written rules and laws made by the legislature or in official statutes. The main legislative body in South Africa is Parliament. So all laws made by Parliament are written as Acts of Parliament. The In Duplum Rule, as mentioned, means double the amount and is a common law rule that limits the interest which a creditor can charge on an account that is in arrears. In common law, the In Duplum Rule considers that interest stops running when the unpaid interest equals the outstanding capital. It therefore provides protection against the exploitation of consumers who cannot service their debt commitments. Here is an example of the common law In Duplum Rule that I am referring to. Let's assume that your debt owed is 2,000 Rand. According to the common law In Duplum Rule, the creditors can charge interest up to 2,000 Rand at the time that you default. So if you default when your debt is 2,000 Rand, they are entitled over a period of time, if you make no more additional payments, to add additional interest of 2,000 Rand. And that means that the debt now owed is 4,000 Rand. The National Credit Act is an act of Parliament. Essentially, this act aims to protect South African consumers such as yourself by regulating credit granting practices, by making credit and or loan applications transparent, fair and easy to understand. The National Credit Act aims to give consumers the knowledge and power to manage their debt effectively and pay it back comfortably. And this is one of those issues that you should take note of. Section 103, subsection 5 of the National Credit Act specifies that not only the interest that must stop running when the unpaid interest equals the outstanding capital, but also that initiation fees, service fees, credit insurance, default admin charges, and collection costs should all be included together with the interest in a total amount which should not be more than the principal debt. This is a good example of how the National Credit Act provides protection for debtors such as yourself by including all these costs incurred in collecting payment from the debtor. This means in a long drawn out and costly collection matter, the collecting parties will get less and less if and when the interest and the legal costs exceed the principal debt. What this actually does is it prevents any unscrupulous debt collector from having carte blanche in adding as much as he likes in collection costs. What all this means is the amount referred to in sections 101 of the National Credit Act, which accrues while the consumer is in default, may not exceed in total the unpaid balance of the principal debt when the default occurred. Once the total charges equal the amount of the unpaid balance, no further charges may be levied. Once the total charges equal the amount of the unpaid balance, payments made by a consumer thereafter during a period of default do not have the effect of permitting the credit provider to charge further interest while such default persists. In Duplum only applies to what they call arrear interest and not the normal interest that is charged as per the contractual agreement. Interest is still charged as per the contractual agreement. When you default, additional interest is charged on the arrears amount, which the credit providers call arrear interest. This arrear interest plus any collection costs may not exceed the unpaid balance of the principal debt, that is the capital amount outstanding as at the time of the default. The common law in Duplum Rule does not prohibit or prevent or stop the interest from accruing again once the outstanding interest has been reduced below the In Duplum limit. In other words, it can be added and added again. In other words, if a payment is made and the outstanding amount is reduced below the outstanding principal debt, the In Duplum Rule will no longer apply and interest can start running again until it reaches the In Duplum limit once again. That is under the common law. Whereas the statutory rule, as in the National Credit Act, applies for the entire duration of the default, meaning that as long as a consumer remains in default of his or her payment obligations, the credit provider is not entitled to levy any further charges, in spite of the fact that a consumer may reduce the outstanding charges through repayments, which is in the direct opposite to the common law rule. As a result, the statutory rule provides greater consumer protection, whilst credit providers are left considerably worse off. There are two kinds of credit agreements that we can refer to. There are those that fall under the National Credit Act, and there are those that do not fall under the National Credit Act. For all agreements that do not fall under the National Credit Act, the common law In Duplum Rule applies. In other words, the statutory In Duplum Rule applies to all credit agreements that fall under the National Credit Act, and the common law In Duplum Rule to those credit agreements that do not fall under the National Credit Act. And then very importantly, credit providers are precluded from trying to contract out of the statutory In Duplum Rule. Here we have an example of the common law In Duplum Rule. Let's assume that the debt at the time of default is 2,000 Rand, which means that the creditor is entitled to charge interest up to 2,000 Rand during that default period. And let's assume that no more payments are made. The debt is owed then is 4,000 Rand. Let's assume further that the debtor makes a payment of 400 Rand. The debt is then reduced to 3,600. But the creditor is entitled to add additional interest to that amount if no more payments are forthcoming, and the debt will increase again to the 4,000 Rand. And so it will go on and on and on, and this debt will take forever and ever to be paid off, because the interest can always be charged up to the amount of the initial debt at the time of default. That is the example of how common law works. And note too that it only applies to interest. Only interest, only interest. but it keeps pushing the debt owed up to the original amount at the time of default. Here we have an example of the statutory in Duplum Rule. Let's assume that the debt is 2,000. Now, if you remember, in the case of the common law rule, 2,000 Rand interest could be added. But in the case of the statutory rule, all of these costs must also be included, which means that you're going to, this amount will be reached so much sooner. So let's assume that no payments are made and the default amount is 2,000. It means that up to 2,000 Rand can be added to the default debt, which is inclusive of all of these costs. And let's assume that it happens, and the debt owing is now 4,000 Rand. Now, if you recall, in the case of the common law rule, if you made a payment and no payments thereafter, the debt was reverted back to what it was with additional interest added. But in the case of the statutory in Duplum Rule, it's just the opposite. Let's assume that that is now the default debt owing with all these costs added, and you make a payment of 4,000 Rand, 400 Rand, I beg your pardon. The debt is now 3,600. It has been reduced by 400 Rand. And let's assume you make another payment of 500 Rand for argument's sake. The debt will then be reduced to 3,100. And so it goes on until you reach naught. And that is how the statutory in Duplum Rule differs from the common law rule. As you make payments, the credit provider and the debt collectors cannot reverse this up again or add additional costs until you've settled the debt, or it allows you to settle the debt. So this is a much better option, or better proposal for you, the debtor, as opposed to the common law one. And remember, the statutory in Duplum Rule only applies to credit agreements that fall under the National Credit Act. If you go to a credit provider who is not registered with the National Credit Act, he does not fall under the National Credit Act, therefore this won't apply, and the common law rule would then apply. So make sure that the credit agreements that you get involved with are always compliant and fall under the National Credit Act. Right, just to sum up quickly, the common law in Duplum Rule only applies to interest. Only interest. That's the common law in Duplum Rule. The statutory in Duplum Rule limits all interest and all of these costs to double the amount of the original debt. Double the amount of the original debt when someone is in default. That is all for this video. Let us help you resolve your debt problems. Request an assessment from us, which is totally obligation free, completely confidential, and then you decide. If you assist, or if we assist you, we will ensure that you are not overcharged with arrears, interest, etc. Why not give us a call and see how we can help you in your situation? You have nothing to lose but your debt. Thank you so much for watching, and I hope you will benefit from this video. Please share it with at least one friend. Who knows, you may be helping him or her as well. Thank you.